Well, there are a few. I mean, there's a nice... I talk about quite a few Australian cases in the book, and there's a nice Australian case where someone's making a proprietary estoppel claim against someone who is themselves making a proprietary estoppel claim. So I quite like that one. But I think it's actually quite an important case, which isn't actually very well known because it's unreported decision of the Court of Appeal called Walton and Walton from 1994. And Lord Justice Hoffman, as he then was, gave an important judgment there that's been picked up in some of the later House of Lords cases. And in that case, I think Lord Justice Hoffman, as he then was, he gives a very nice definition of proprietary estoppel, contrasting it with a contractual claim and saying that what you do in proprietary estoppel is you look backwards from the time the promise was made to see if it would now be, we look backwards from the facts to the time the promise was made, and you see whether it would now be unconscionable for the promisor to renege on the promise without giving anything to the promisee. And that's different from a contract, whereas with the contract is immediately binding, come what may, subject to the narrow doctrine of frustration, he says. And that ties in quite nicely with something Lord Hoffman says later on in a House of Lords case, where he quotes Hegel, and he says, the owl of Minerva spreads its wings only with the falling of the dusk. And he's using that there to say that the interpretation of a particular statement may depend on later events. So he's using it in that specific context, but I think it ties in with that broader idea about proprietary estoppel being a sort of backwards-looking doctrine, at least when dealing with the promise-based strand. And it also works on another, still broader level, which is that when the judges are developing the law through their decisions, it's very difficult. It's only when you stand back and look at that development of the cases that you can tell what the actual principles are. And that's something that I'm trying to do in the book. Although, of course, the interesting thing is the cases will keep on coming and developing, and you can never be completely confident as to what the law is and as to how the law will develop. But you can try to take a stab at setting out those principles in an organised way, and that's what I'm trying to do in the book.